Hi guys, welcome back. Today we are starting part 3 of the Constitution, the fundamental rights. So if the preamble gives the philosophy, fundamental rights gives the protection to us. They are the backbone of the Indian democracy because without fundamental rights, the democracy becomes a majoritarian rule. So why were fundamental rights needed? If we see historically, India experienced colonial oppression, arbitrary arrests, and the suppression of speech, racial discrimination. So, framers wanted the protection of citizens from the misuse of the power. So, fundamental rights guarantees against state arbitrariness. Okay, so these are the negative obligations on the state. Okay, so next we will see the significance of the fundamental rights. Significance of the fundamental rights are they protect the individual liberty. The fundamental rights protect freedom of speech, movement, right to life, and personal liberty. They create the sphere of economy for individuals and limitations on the state power. The government is powerful, so the fundamental rights act as limitations on that power. The state cannot arrest arbitrarily, discriminate unfairly, suppress freedom without a reason. Okay, so they check the executive and legislative action also, and essential for democracy. These fundamental rights are essential for democracy. Democracy is not only elections. Democracy requires free speech, political opposition, and equality before law. Fundamental rights make democracy meaningful, and they also promote equality and social justice. So we have around seven fundamental rights on the inception of the constitution, and later after 1978 it came down to six fundamental rights: right to equality, right to freedom, right against exploitation, and right to freedom of religion, cultural and educational rights. If we say right to equality, the articles from Article 14 to 18, right to freedom is Article 19 to 22, right against exploitation is Article 23 to 24, and right to freedom of religion is Article 25 to 28, and cultural and education rights is Article 29 to 30, right to constitutional remedies is Article 32. Okay, first we will see the article 12 and 13 first, and then we will move into the fundamental rights one by one. We have discussed till article 11 in our last video, citizenship. Now we will start the article 12. So before we studying the fundamental rights, we must understand against whom these rights are enforceable. Okay, because fundamental rights primarily protect individuals against state. So we have to see what is the state. So the state includes government and parliament of India, government and legislature of states, and three local authorities and four other authorities. We will see what do they mean individually. First, government and parliament of India. So this includes president, prime minister of India, and council of ministers, Lok Sabha and Rajya Sabha. So central executive and legislature are state. Okay. Next, so if any of these people violate, we can go to court that our fundamental rights are violated. Next, second point, government and legislature of the states. This includes governor, chief minister, state council of ministers, and state legislature. So the state governments are also the state under the Article 12. Okay, if any of these people violates our rights, we can say that our rights are violated, fundamental rights are violated. Next, local authorities. This includes municipalities, panchayats, district boards, improvement trusts, etc. So these bodies exercise governmental functions. Okay. Next, other authorities. This is the most debated and important category. Other authorities include bodies that are created by the constitution or statute and performing public functions controlled by government. Example: public sector undertakings, government companies, statutory bodies, universities, boards. So the courts have expanded this through judicial expansion. The Supreme Court has interpreted other authorities broadly. We will see the what the courts have expanded through the judicial expansion in the next. In judicial expansion, Supreme Court has interpreted other authorities broadly. If a body is financially controlled by the government, functionally controlled by the government, and or like administratively dominated by the government, it can be treated as a state. So this is called the instrumentality or agency test. Let's say if a company is shared between private and government, if 51% is owned by the government and the rest 49% is owned by the private, it is considered as a state only. So why this matters? If an organization is a state, its actions can be challenged under article 32 or 226. If not state, the fundamental rights generally cannot be directly enforced. So here important clarification is the fundamental rights are mainly enforceable against the state. Okay, mainly enforceable against the state, but some rights like article 15 clause 2 and article 17 article 23 can operate against private individuals also. So article 15 clause 2 is prohibition of discrimination by any citizen on grounds of only of religion, caste, race and sex, place of birth, like shops, restaurants, hotels, public places of any entertainment, wells, tanks, bathing guards, and roads, etc. Okay, so both against state and the public individuals. This Article 15 Clause 2 applies to. Okay, next Article 17, abolition of untouchability. This is absolute law. Okay, it applies to everyone. Next Article 23, prohibition of human trafficking and forced labor. This is also both against the state and public. Next, we will discuss Article 13, laws inconsistent with the fundamental rights. This has four clauses. Clause 1 is pre-constitution laws void to extent of inconsistency, and clause 2, state shall not make laws violating fundamental rights. Next, clause 3, meaning of law. Next, clause 4, 24th amendment, constitutional amendments excluded. Okay, you will see one by one. So article 13 is the guardian of the fundamental rights under the Constitution of India. It ensures that the state cannot make laws that violate fundamental rights. Okay, here we will see this by the doctrines of judicial review, doctrine of eclipse and doctrine of severability, and important cases like Golaknath and Keshwanand Bharati case also involved in this. Okay, so here the clause 1 deals with the pre-constitution laws. That means the laws made before 26 January 1950. If any such law violates fundamental rights, it becomes void, but only to the extent of inconsistency. Here it comes as a doctrine of eclipse. The law is completely not dead; it becomes only inactive or means it remains on the statute book but cannot be enforced against the citizens. Okay. Next, if we see the doctrine of severability, if only a part of law violates fundamental rights, only that part is struck down and not the entire law. Okay, only the unconstitutional portion is removed and valid portion remains enforceable. So this both explains the doctrine of eclipse and the doctrine of severability. Next, clause 2, This clause restricts future laws. The state shall not make any law that takes away or abridges fundamental rights. If it does, that law becomes void. Next, clause 3. Here, the Constitution defines the word law. It includes ordinances, rules, regulations, notifications, and even customs having force of law is considered as a law. Next, clause 4. This clause was inserted by the 24th Amendment to override the judgment in Golaknath versus State of Punjab. In Golaknath, the Supreme Court said Parliament cannot amend fundamental rights, but later on, in the case 1, the Bharati case versus State of Kerala, the court said Parliament can amend fundamental rights but cannot destroy the basic structure. Okay. Thanks for watching. Next, we will discuss right to equality from Article 14 to Article 32. We will try to cover in the next video.